In a standard civil trial, the timeline moves linearly. The plaintiff files a complaint, issues are joined, and the plaintiff presents their witnesses and documents. Then comes a critical juncture, the moment the plaintiff formally rests their case. At this point, the burden shifts. The defense must now spend months or even years calling their own witnesses, hiring experts, and accumulating billable hours to refute the claims. But if the plaintiff's presentation was weak, the defense has a procedural shortcut, Rule 33, the demurrer to evidence. This mechanism allows the defense to seek an immediate dismissal before presenting a single piece of their own evidence. The core argument of a demurrer is straightforward. The defense tells the judge, even if we assume everything the plaintiff just presented is entirely true, the facts and the law show they have no right to relief. The court evaluates this motion by looking exclusively at the plaintiff's side of the board. The defense's own counter-evidence does not exist yet for the purpose of this ruling. While Rule 33 offers an early exit, it carries a specific procedural risk. Depending on the outcome, a defendant may lose the ability to ever present their side of the story. By filing a demurrer, the defense anchors their entire procedural standing to the absolute inadequacy of their opponent's evidence. The mechanics of this maneuver are codified in Rule 33, Section 1. Let's look directly at the text to understand the exact requirements. First, the timing trigger is absolute. The motion can only be filed after the plaintiff has formally completed the presentation of their evidence. You cannot file a demurrer midway through their witness list. To map the structural flow, we use the mnemonic CNDR. C stands for completed plaintiff's evidence. N is the substantive legal ground, no right to relief. The defendant explicitly argues the plaintiff's case is totally insufficient. D covers the first outcome, denied. If the judge denies the motion, the defendant safely retains the right to present their own evidence. Alternatively, if the trial judge agrees and grants the motion, the case is immediately dismissed in favor of the defense. When the judge evaluates this motion, the facts they review include the plaintiff's testimonies, documentary exhibits, judicial admissions, and any stipulations made during pretrial. Crucially, this evaluation strictly excludes any evidence the defendant might be holding in reserve. The trial court's evaluation of a demurrer acts as a one-sided stress test. It is engineered to identify and expel hollow claims before the defense is forced to expend resources defending against them. To fully grasp how the civil demurrer works, we have to isolate it from its criminal procedure counterpart, found in Rule 119. Confusing the two on a bar examination leads to entirely wrong conclusions. Looking at this matrix comparing the two, the defining procedural difference is permission. A civil demurrer under Rule 33 never requires prior leave of court. You simply file it. In criminal trials, filing without leave alters the stakes. In a civil case, guessing wrong doesn't penalize you. A denial never results in a waiver of your right to present evidence. But if you file a criminal demurrer without leave and get denied, it triggers an automatic waiver. The outcomes of a successful motion also diverge. A granted criminal demurrer acts as an acquittal. Because of double jeopardy, it is immune from appeal. A granted civil demurrer lacks that absolute finality. If the trial judge dismisses the civil case, the plaintiff is free to appeal that dismissal to a higher court. A civil demurrer lacks the finality of a criminal acquittal. But because a trial-level denial does not strip the defendant of their right to present evidence, it remains a safer initial attempt. This brings us to a highly specific, high-risk scenario.
Imagine the trial judge agrees with the defense and grants the civil demurrer. The case is dismissed, but the plaintiff appeals the dismissal to the Court of Appeals. The appellate court's objective here is to determine if the trial judge made a mistake. They review the record to see if the plaintiff's evidence actually was legally sufficient. This triggers the final letter of our CNDR mnemonic, the R for reversed. This happens when the appellate court overrules the trial judge's dismissal, deciding the plaintiff did show a right to relief. This reversal triggers a severe statutory consequence. Because the defendant chose to file the demurrer instead of presenting their case, they are now permanently deemed to have waived their right to present evidence. This exact sequence is a classic bar examination trap. It's tempting to assume the appellate court should send the case back to the trial court so the defense finally presents witnesses. That assumption is legally incorrect.
The correct procedural mandate is absolute. The appellate court must immediately decide the entire case, rendering a final judgment based exclusively on the plaintiff's unchallenged evidence. The primary risk of Rule 33 is winning at the trial level, only to have an appellate court reverse the victory. This sequence leaves the defense disarmed, subject to a final judgment without ever presenting their side. Historically, defense attorneys weaponized the demurrer. Even if they knew the case was strong, filing a demurrer could grind civil trials to a halt, forcing the court to entertain the motion and delaying the presentation of defense evidence for months. The Supreme Court addressed this systemic delay with the 2019 amendments to the Rules of Civil Procedure, creating a fortified Rule 33, Section 2. The new section explicitly classifies the demurrer to evidence as a litigious motion. This subjects it to the tight, non-negotiable time constraints of Rule 15. This digital timeline shows exactly how strict those constraints are. Once the demurrer is filed, the opposing party is granted exactly 5 days to file an opposition. From there, the clock shifts to the judge. The court is mandated to resolve the demurrer within 15 days of receiving the opposition, or after the 5-day period expires. To ensure this timeline holds, the rule forbids the filing of any other submissions. No replies, no rejoinders, and no supplemental pleadings will be considered during this resolution phase. The 2019 amendments replaced the historical delay with a fixed 20-day resolution cycle that ensures the trial proceeds quickly. Consider a scenario where a trial judge completely ignores the law and wrongfully denies a demurrer that was perfectly supported by the facts. Before 2019, a defense lawyer's instinct would be to halt the trial and elevate the issue to a higher court, filing a Rule 65 petition for certiorari and alleging grave abuse of discretion by the trial judge. Section 2 established an absolute prohibition against this exact maneuver. The rule is explicit. An order denying a demurrer to evidence cannot be the subject of an appeal before a final judgment is rendered in the main case. Furthermore, it cannot be elevated via any extraordinary writs. Petitions for certiorari, prohibition, or mandamus are entirely blocked. The trial cannot be paused. What is the single remaining legal remedy for defense counsel facing an abuse of denial? The defense has only one option. They must proceed with the continuous trial, present their own evidence, and wait to assign the judge's denial as an error only when appealing the final judgment of the case. Rule 33 operates as a surgical tool to remove baseless litigation, but the 2019 amendments ensure it cannot be used to stall the judicial process.